Hello, everybody. Welcome to the leaflet. We have today with us Professor G. Mohan Gopal, a former director of the National Law School of India University, Bangalore, and a former director of the National Judicial Academy, a very renowned scholar. He recently wrote a very thought provoking piece after the death of activist Stan Swamy, in which he made some very interesting and innovative points. And basically, he asked for the review, an independent review of the role of courts in Father Stan Swamy's death. Dr. Gopal, I would like to start with a point that you make in your article, which I believe nobody has made, which is narrative independence. What do you mean by narrative independence? Do you mean that the courts often get swayed by the public narrative or even the narrative built by the government when dealing with cases involving allegations of terrorism?
No, I think let me start by reflecting for a minute on what is a narrative, right? So there is a whole field called narrative psychology, and there's a famous quotation from one of the thinkers in that field, which says the world is not made of atoms and molecules. The world is made of stories. And so narratives are very fundamental to the way in which we understand the world and relate to the world at an individual level, as individuals, as groups, as institutions. Our perspectives are shaped by narratives, right? So that there is a narrative is an as essential a part of humanity as it is to breathe, and and unavoidable. The question is, what is the narrative? And are we critical about the narratives that control and influence us as human beings? That's the first point. The second point is the law as a discipline is actually a method of thinking about and interrogating narratives and making sure that narratives are actually grounded on facts. And the Evidence Act very beautifully describes facts as things, or a state of things, or a relationship between things that are perceptible by the senses, or a mental condition of which we can be conscious, which means that the law provides a requirement as a matter of discipline that we must question whether the narratives are based upon things that are perceptible by our senses, verified by going through the exercise of saying, okay, who has perceived this fact, not who imagines this fact or speculates this fact. So what is not perceptible by the senses, such as suspicion, speculation, superstition, is not admissible in court as a fact, and therefore cannot be the basis of legal decisions. And therefore, we have two things. One is we have narratives, which is a reality, a psychological reality and a social reality. And the other is we have a technology for making sure that these narratives are actually based on fact, meaning things that are perceptible by the senses or perceptible to others, which are objective. And the word objective actually comes from the word ob, which is the same ob as in observe, right? A thing. And yective comes from what is in front of you. So objective means, objectivity is the heart of judging and the heart of the legal process. It is that you should only make decisions based on objects, on things that are perceptible to you and that are independent of your subjective perception. Independent. Subjective is what is under your control. Objective is not what is not under your control, not manufactured by you. So you take all this together, we have narratives and we have a technology called law to protect us from narratives, from false narratives, because that's a big risk to us that false narratives are constructed. So against this background, what is happening all over the world is that one party or another and the other perhaps in court presents narratives saying this person must be sent to jail, or no, I'm completely innocent, I've done nothing wrong. These are all narratives. So how does a court find its way forward in the midst of these conflicting narratives? By focusing on facts and evidence. And those facts must be not facts which are not under the control of the judge or the court. Then it's subjective. When it is under you, what you observe is under you, under your control, because then you can shape it the way that you want it. Whereas if it is objective, it's outside you, then it is something that you have to take as you perceive it, rather than something you can control. Therefore, the starting point is to say that we must be independent of narratives, using the methods and technologies given to us by law. Now, the best illustration of that is something I referred to in that piece, which is a very, very tough case, a case which I think is similar to involving terrorism, allegations of terrorism, accusations of terrorism, of the worst variety, in the sense of associated with the murderous attack on the World Trade Center, in which thousands of people died. This is a case called Hamdan versus Rumsfeld, where there is an associate of Osama bin Laden, no less, direct associate, a part of his team, who is being tried. And the narrative of the George Bush administration is that this man is a very dangerous man, and he has killed people, or he has been associated with killing people, he will do that again. And so Justice John Paul Stevens, who's writing this judgment, judge of the US Supreme Court, he is no more with us. But at the point he wrote this judgment in 2006, he had already been a judge of the United States Supreme Court, not other courts, just of that United States Supreme Court for 37 years. For 37 years, just a judge of the US Supreme Court. So you can hardly imagine a judge with greater experience of at the highest level, the apex court of a country, than him. And then he writes something which I write in the article, and I'll just take 1 second, if you permit me, to quote it, because that will answer your question. Justice John Paul Stevens writes, "We have assumed, as we must, that the allegations made in the government's charge against Hamdan are true." So he says, look, I accept your narrative as true. "We have assumed, moreover, the truth of the message implicit in that charge, namely that Hamdan is a dangerous individual whose beliefs, if acted upon, would cause great harm and even death to innocent civilians, and who would act upon those beliefs if given the opportunity. It bears emphasizing, that's next is a procedural point. But in undertaking to try Hamdan and subject him to criminal punishment, the executive is bound to comply with the rule of law that prevails in this jurisdiction." This is a declaration of narrative independence. "I'm not questioning your narrative," he says. "I accept your narrative. But the rule of law has to be independent of a narrative. It can only be based on facts, not on narratives or stories." Now, this is the background to it. What we are facing in our own country is basically unquestioned narratives, which are reinforced in the media, which are reinforced in the public consciousness, that feed into the fears of the people. And I'm sure there are elements of truth in the narrative sometimes. I'm not examining that. But ultimately, these narratives are painting Stan Swamy, who's a man whose life has been an open book for his entire life, and various others, as the George Bush administration did, as terrorists.
You quoted from this case called Hamdan versus Rumsfeld. This reminds me of a movie I recently watched, Mediterranean. It's on Amazon. It's a very interesting movie, again based on a similar case, where Salahi, a Mauritanian national, he is kept in confinement in Guantanamo Bay for almost 14 years before released. There, a lawyer, a criminal defense lawyer called Nancy Hollander, played by Jodie Foster. She makes a very interesting point. She says that I'm not just defending Salahi, I'm defending the rule of law. The Constitution, she says, does not come with an asterisk at the end which says terms and conditions apply. So in that case, I just to take this conversation forward, in that case as well, uh, he was acquitted, and the US District Court Judge James Robertson, he said, Salahi may well have been an Al-Qaeda sympathizer, but the government has failed to adduce evidence to show that he was part of the Al-Qaeda's command structure, and he was acquitted. Now, that's a very brave judgment. Now, you talked about Hamdan, I spoke about Salahi judgment. Recently, Delhi High Court also gave a very brave judgment while granting bail to a couple of student activists. And immediately there was a pushback and there was a backlash. And one would say that there was also a pushback by the Supreme Court of India, which almost stayed the operative part of the judgment, barring the fact that the accused were allowed to be out on bail. Now, while it is one thing to say that there should be narrative independence, but it is entirely another thing when the judges in their individual capacity, or sometimes acting as a part of the bench, they do uphold narrative independence and they are faced with the backlash. So what do you have to say about that? Because judges obviously are part of the same system. How do they cope up with this kind of pushback by the system and by sometimes by the society at large?
Let me start by recalling that a very respected senior judge once took gentle objection when a reference was made to an honest judge. He said, look, that is, every judge has to be every judge has to be honest, and you can talk about dishonest judges, but you should not qualify a judge as an honest judge, because if he's a judge, he has to be honest, or he's dishonest and he's not a judge. So similarly, I recall that because when you said brave judge and brave judgments, right? There's nothing courageous. They're being appointed and paid very handsomely and given lots of privileges and benefits and enormous power in order to uphold the rule of law. So there's nothing brave. It's the first and most primary thing that a judge has to do, is to understand and uphold the rule of law and be accountable for it. And what does the rule of law involve? It involves, one of the things it involves is basically to make sure that the standards and procedures laid down in the law are applied to reach determinations of courts and uninfluenced by powerful narratives that the state or the defense may mount in front of you. For example, that this defendant is unimpeachable. I once sat in a district court in the country where someone had been arrested for murdering, for the death of a woman in his house, for murdering her. Was a father-in-law. I don't remember the details, obviously. But the defense narrative, which I heard myself sitting in that trial court, asking for bail for this man, the court was not influenced by that narrative. But the narrative was, sir, he's a Hindu. A Hindu cannot kill his daughter-in-law. This was the narrative mounted by the defense. And the judge maintained narrative independence and said, so that's not relevant to the question whether he's entitled to bail. So I think, first of all, we must realize that we cannot lower the bar so much and say these are brave judgments. The Delhi High Court judgment is a correct judgment. It's a correct judgment, which interprets and understands the law correctly and painstakingly explains why it reached that decision based on law. It could not have reached any other decision, right? Now, the Supreme Court is yet to examine that judgment on the merits of the law. They've made some interim orders. The issue is that it will not apply as a precedent. I'm not sure what the legality of that. I've not seen the order on that, and if there is such an order, I'm not sure what the legality of that is, because the principle of stare decisis, namely that it will bind the courts within the jurisdiction that it has, cannot be amended by a dicta of the Supreme Court from the bench. It cannot be, because it is really, it is part of our non-negotiable, non-derogable values, that on the basis of which rule of law operates. That when a high court or a Supreme Court lays down a judgment, the ratio decidendi is applicable to the courts over which they are supposed to apply. And so I think that raises lots of issues. So yes, there is a backlash, but the sad thing is there is a backlash against normal, correct judging, right? And it is as if the narratives are trying to overwhelm the rule of law and sweep aside the rule of law, and the narratives must be the basis of judicial decision making. So independence of this narrative, as exemplified by two normal judgments, not brave judgments, one by Justice John Paul Stevens, and there are many others, but as illustrations, one by John Paul Stevens, one by the Delhi High Court, are normal judgments that we expect from every single judge, and to be guided only by the processes of judicial decision making laid down by legal principles and statutory provisions, and not be influenced by the narratives presented by either side. And that is a very important element of judicial independence, which we, in our country, in the current circumstances, we really need to question very carefully whether the narratives are coming in the way of the rule of law. I believe they are in many cases from what one reads in the papers, but it requires careful examination.
Uh, Taking this thread of narrative independence forward, you talked about Hamdan's case. I spoke about Salahi's case. At least there was an assertion there by the government that they were part of the Al Qaeda network. Al Qaeda carried out terror attacks, including 9/11, which killed hundreds and hundreds of innocent people. Also, in the case of Delhi riots, there was violence and at least 50 people were killed. But Stan Swamy's case stand on a different footing, because even if the narrative is taken on its face value, the allegation is not that he triggered some riots. The allegation is not that he instigated some conspiracy which led to bomb blast. The allegation was merely that his computer had certain communications or files which may lead to the possibility that he was part of some wider network of Maoist sympathizers. So it was kind of a very weak case in terms of a public narrative, which often the government builds against terror cases. So even in this case, an 85-year-old priest arrested on the basis of what would many call flimsy evidence. Why were the courts so cagey? Why were the courts so reluctant to grant him bail? I want to ask you why there was just complete, which you call complete judicial abdication. The former Delhi High Court Judge A.P. Shah has also referred to a complete judicial failure. Why was there such complete judicial failure to even accord him bail?
No, I think we should distinguish two things. One is the material, the evaluation of the material presented against a particular individual. Let's say in this case, Father Stan Swamy, right? Versus assuming that the material is rich and abundant, but fiction, rich and abundant fiction, right? You're not suggesting that then there was a basis to deny him bail. It is not the thickness or thinness of the fiction that should decide whether you get bail. The question is, how should you evaluate that evidence? What are the judicial standards on evaluating that evidence? Because if you say that there was hardly any allegation against him, I don't think any of us have. I've not seen the actual, the submission to the court, the evidence or the charge that was given to the court. And let's say you're right, and it was very thin, right? But so are we suggesting to the government then that they should sort of use more imagination and creativity and submit a thick set of false facts against people and that would justify bail. No, we are not. So what we should really look at is what does the rule of law require a court to do in deciding to deprive deprive someone of his liberty and put him in jail. So we have the preambular assurance of liberty. We have Article 21 that gives us the right to, fundamental right to life and personal liberty. We have various elements of Article 19, the right to be able to speak without being arrested and thrown in jail as a result. That's a restraint on speech and expression. So we have multiple protections which we now know are all integrated, mutually supportive, and there's an architecture of liberty and freedom in the Constitution, and that is being attacked. Now, the Constitution sets out very clearly and specifically the grounds under which, or authorizes the setting out of grounds under which liberty can be deprived. Equality cannot be, no restriction can be placed on equality or dignity, but on restrictions, reasonable restrictions on liberty can be provided. Now, this happens at two levels. One is at the level of the law. Are the restrictions authorized by law reasonable or not? And do they fall within the permitted parameters of restrictions, or the requirement that there must be a just, fair, and reasonable process of deprivation of liberty as required by Article 21, and so on. Now, maybe a legislation like UAPA has so far passed muster, although I personally believe that it is unconstitutional, but it has passed muster with the judiciary. It's not been declared unconstitutional. So that's one level. The second is when it is applied to the facts and circumstances of a case. When it is applied to an individual and there are specific allegations made against that individual, what is the responsibility of the individual court? So you're dealing with a statute that is not yet found to be unconstitutional. It's part of the law of the land. Does that mean that the statute then steps in the place of the entire Constitution and takes away all your constitutional rights, and simply complying with that Constitution with that statute in its generality guarantees protection of your constitutional rights? And I mean, the clear answer in all our jurisprudence and all over the world is no. In fact, the opposite. It is in the application of these laws and to the particular case that the protection of the Constitution, in fact, it is only in those cases that the protection of the Constitution actually applies and is relevant. Otherwise, it simply remains on paper. It's only when you are detained that the Constitution kicks in. And the statute even then cannot conflict with the Constitution. So that's when Stan Swamy's rights under 21, the right to life and personal liberty, under 19, kicks in when UAPA is enforced, is not displaced by UAPA. And that includes his right to bail, flowing directly from his right to liberty under Article 21, and his right to speech and expression, to engage in activities, his right to association under Article 19. So the individual court, not only judge, but the lawyers who are handling his case must protect the Constitution and subject the evidence or the charge before that to the constitutional test, not only the statutory test. The Constitution is a constant presence everywhere, even in our private spaces. It is constantly there. When a woman stands up in the middle of the night at home and tells her husband, "You will not beat me," and invoking the Protection of Women Against Domestic Violence Act, a very revolutionary and wonderful piece of law that Madam Indira Jaising led when it was introduced in this country. When a woman says that to her husband, she's asserting a constitutional right, not only a right under the Protection of Women Against Domestic Violence Act. That's only a fleshing out how to protect those constitutional rights, not replacing them. And the Constitution is a constant presence, protective presence in our life, our fundamental rights. And the judge is the guardian of that protective presence and the enforcer of that protective presence. So frankly, the quality of how many charges they had against Stan Swamy is really much less relevant than the fact that they had no right under the these restrictions were unconstitutional, and the UAPA must be read subject to the Constitution. The Constitution should not be read subject to UAPA. The right to bail must be read subject to the Constitution. The Constitution cannot be read subject to the UAPA right to bail, and that would be a very, I think, wrong and very short-sighted view of looking at the rights of people. And that's where the failure is taking place. The relationship between statutes and the Constitution and the principles of law, what we call jus cogens, peremptory norms, which are globally accepted as non-derogable and non-violable, including the rule of law. And I want to say that actually the rule of law is what gives us protection from fear. And one of the most important causes of fear and terror is being ruled arbitrarily and subjectively by armed and powerful people who will engage in violence against you. And this is the great fear of most individuals. And so when you violate the rule of law, you are actually causing fear and terror in the minds of people. And that is in itself, violation of the rule of law in itself must be seen as an act of creating terror. In other words, a terrorist act to create terror in the minds of people, because ultimately all these laws against terrorism are intended to protect the people from having to live in fear and terror. That is the real purpose, right? Not just to protect the officials of the state. And so the violation of the rule of law is usually the first objective of terrorists. Destroy the Constitution, destroy the rule of law. And the rule of law, violation of law cannot be the basis of protecting law. So the Stan Swamy issue raises a very fundamental question. Was the rule of law breached? Was the Constitution breached? That's what we want to know. Not simply whether the charges were strong enough or not. We know the narrative, the public narrative against him was very strong. He was seen as he was painted as some kind of mastermind behind violent extremist activities. And that may have contributed to the manner in which he was treated, in prison, or his right to bail was viewed, and the failure of the law to protect him. So yes,
Professor Gopal, the reason I pointed towards the perceived the reason I pointed towards the perceived flimsiness or the perceived thinness of the charges or the evidence against Stan Swamy is because I wanted to ask you a pointed question. Is it the UAPA and the stringent provisions of UAPA, like Section 43D5, which makes bail, unlike in general criminal trial, an exception and not the rule? Are these statutory provisions standing in the way of courts, higher courts, or even the Supreme Court from letting people out on bail?
It takes you to the question of Justice Krishnaya's famous dictum, bail, not jail. Now, why did he say that? He didn't anchor it on a particular statute or the criminal procedure code. He anchored it on constitutional principles. The presumption is that that bail should be given, and jail should be required only in very exceptional circumstances. And even in the statute, in Section 41 of the Criminal Procedure Code, there are the well-established principles on when custody is necessary, and they basically have to do with interference in one form or the other with the judicial process and the trial process. Namely, person may escape, may flee, may interfere with the evidence, may put duress on the witnesses in some or second ground. So one ground is interference with the judicial process. The second ground is protection of the accused himself or the person being kept in custody, or the protection of someone else. who may be in danger if this person is released, there can be no other ground to detain someone. It is not, the question is really not only the right to bail, but real question for the judges, the court is, the state, the executive is demanding that restrictions be placed on the liberty of a citizen. Is this a permissible restriction or not under the law? And if it does not meet the standard of permissible restrictions, that person cannot be detained. And the principles of what is permissible restriction on liberty are, emanate, recognized. The recognition of these principles emanate in the Constitution, not in the UAPA. And the UAPA can only be constitutional if it is read subject to these constitutional mandates and provisions. So if you look at that, one very big mistake on which is happening routinely in our country, and I've written about this also, is the idea of custodial interrogation. Custodial interrogation. Many judgments also say that some custody is required so that the person can be interrogated. This is a blatant violation of the constitutional right against self-incrimination. A person is not expected to help the case to build a case, help the state to build a case against yourself. The state has to build a case against a person independent of that person. That is a right against self-incrimination. You are not obliged to help the case, the prosecution build a case against yourself. And it is because that is seen as possible that you're tortured, because you are seen as responsible to prove that the suspicions against you are right. And so you're forced sometimes to speak the untruth just to stop the pain of torture. And this torture includes putting you in jail. So I take the view, yes, there's a separate question. If you are in custody on grounds, these two broad sets of grounds that permit the state to keep people in custody for protection and for protecting the judicial process, then the question is, can you be interrogated during your custody for other permitted grounds? And the courts have said, yes, you can. You can't say, look, because I'm in custody, I cannot be interrogated. That is not a violation of your right against self-incrimination. But with adequate safeguards, including no torture and so on, and no compulsion, no testimonial compulsion, you can be interrogated, right? But can you be interrogated just for the purposes of questioning you so that you'll be brought under pressure, mental pressure, psychological pressure, you'll be humiliated in society so that you will then agree with the police and the prosecution? That is unconstitutional and absolutely impermissible. It is only a basis for producing false evidence that is partly responsible for the large amount of acquittals that take place, because they rest on evidence constructed out of the pain and suffering of people just to relieve themselves of torture of one kind or the other, and ultimately they don't stand up in court because they are not based on a shred of objective evidence. So I think what we have to the question we have to frame is, did the state in Stan Swamy's case have a right to place a restriction on his right to liberty? And the answer is, the state has no. He was not a threat to the judicial process. He was not a threat to engage in violence or in illegal activities against the state. To our knowledge, they've not produced any evidence of that, or to interfere with evidence with witnesses. And if that was a threat, then as has been said in some judgments, appropriate conditions on bail could have been imposed to guard against these risks. But therefore there was no constitutionally permissible restriction, regardless of what UAPA may say or may not say, to place a restriction on Stan Swamy's right to liberty under Article 21. Sorry, I can't hear you. I think you're muted.
Yeah, Professor Gopal, I want to ask you, has the higher judiciary, especially the Supreme Court of India, tied itself up in knots by, on one hand, upholding the constitutionality of these extraordinary anti-terror laws like UAPA, TADA, POTA, National Security Act, and on the other hand, sometimes they try to fashion out remedies and judicial succor by, like they did in the case of K. Najib when they said that right to speedy trial under Article 21 cannot be trumpeted by special provisions like UAPA. Is there a paradox here? Like, as long as these statutes continue to be be completely valid, the judiciary and the different courts will find very difficult to somehow strike a balance between the constitutional guarantees and what the state is trying to achieve by denying bail and by imposing onerous conditions on people charged with anti-terror law provisions.
No, the question of constitutionality of statutes is not a new one. It's a perpetual question. It should be a perpetual question. We have the right to challenge the constitutionality of legislation, and we will continue to do that. But that should not be mixed up with the question of the constitutional protections continuing to be available for in the implementation of a law that has not been found to be unconstitutional. Even if a law has that which has not been struck down as being unconstitutional is applied, the constitutional protections are meant to apply only in the operation of the laws. So if you take the view that the constitutional protections are not independent sources of rights, regardless of the statutes, in particular instances, then basically you're saying the Constitution is meaningless. So we cannot rely only on declaring a statute constitutional at that macro level as our constitutional protection. And then we suddenly shift from being protected by the Constitution to being protected by UAPA and its language. And this, I believe, is really a hangover of our colonial jurisprudence, where there was no right in the Constitution. It was entirely statutory. If you take the 1935 Act, the 1919 Act, there was a judiciary. In the 1935 Act, it consisted of the High Court and the Federal Court. But there are no constitutional rights for people in the 1935 Act. So you are purely statutory in your judging. But we must realize that the Constitution applies in the sub-statutory space, not in the supra-statutory space. As far as the citizen is concerned, the supra-statutory space is simply an argument between legislature and judiciary in terms of is legislation we enacted constitutional or not. And lawyers, all of us have an active stake in that. But as far as the man or the woman on the street is concerned, it is in the sub-statutory space that the Constitution lives or dies in its application to protect us against sub-statutory state action. And that is the focus.
Professor Gopal, that brings me to a larger question, which is of the large number of under trials languishing in the jails of a country. Yeah. In a conversation offline, you referred that 67% of the total prison inmates are under trials. Now, that's a human tragedy of great proportions, because all of these individuals have families, have children, wives. Many of them would eventually get acquitted, but after a tremendous cost, after paying a tremendous cost. So every person who is in jail because somewhere the judiciary has not exercised its power to grant him bail, or has failed to uphold the constitutional rights. In the article also, you mentioned that granting of bail is a constitutional right, or securing bail is a constitutional right, and it's not an act of judicial grace. So I want you to further dwell upon the role of judiciary today, which I think is not stressed upon enough, especially because it's a closed system. Lawyers and judges, they are part of the same system. As a lawyer, one cannot be critical of the judiciary enough to bring the focus on the failure of the judges in upholding constitutional rights. But I would like you to dwell upon this point that it once a person has been arrested, after 24 hours his liberty is not in the hands of the police, his liberty is in the hands of the judges and the judiciary. So where does the judiciary stand in terms of securing freedom for a large number of people who get arrested, sometimes on wrong charges?
No, I agree. When we spoke just before the interview, what I said was that I did say that 67% of the inmates of India's prisons are under trial. That's a very shameful statistic, and I refer to it as a humanitarian crisis, which is not getting the priority that it deserves. And there are a very small number of people who've been in jail for over 10 years as under trials. And I think that is something that can be easily solved. There are some conundrums in law that are responsible for that, and that can be resolved through judicial interpretation. But I also said to you that every person in this country who is in those prisons for prisons or is in custody for more than 24 hours has been put there by a judge. So we cannot blame the police. The police is only asking for detention, and custody. All these 67% of India's prison population who are there, effectively judges have put them there. They've decided that they will go to jail, that they will be in jail. Right? Do they have the power to do that? Do they have the power to override the constitutional rights of people? The answer is no. They don't have the rights to overcome the constitutional rights of people. And yes, they do have power to put someone in jail, but only and restrict their liberty, but only on the basis of grounds that are constitutionally defined and applied through legislation, not legislatively defined, excluding the Constitution. So it is a responsibility of every trial court, every judge in every court, to understand that their role is a primary role, is a role of defending constitutional rights. This was very beautifully explained in the 117th report of the Law Commission of India by the then chairman of the Law Commission of India, Justice D.A. Desai, where he said, and I'm virtually quoting him from memory, it's not in front of me, but it's almost an accurate quote. He said the Indian judiciary faced an enormous challenge of transforming overnight upon the enactment of the Constitution from being, in colonial times, an extension of the law and order machinery, to becoming, to use his words, a sentinel on the qui vive. A sentinel, a guard on the qui vive means on the alert of the fundamental rights of private citizens. So suddenly overnight, to use the word that Justice Desai used, the judiciary was trained to being a defender of the powerful against the powerless, to becoming a defender of the powerless against the powerful. Complete inversion of the role. And it is on that basis that he said, set up judicial academies to help judges make this transition. Credit to the judiciary, and I've been privileged to be a part of that effort. India has one of the best networks in the world of judicial academies and regular programs of judicial academies, and a lot of conversation that is taking place. That's very recent. It's the last, say, 15, 60 years or so that this has happened at this scale. But that conversation is important to bring about this transition. So you asked the right question, what is the role of the judiciary? The role of the judiciary is actually to uphold the rule of law and protect and safeguard the rights of the powerless against the powerful, because from a physical point of view, there is no need for a judiciary. The state, the executive can arrest people, and put them in jail or kill them they have the physical means to do that. In any case, they are the ones who are physically arresting people and putting them in jail. They don't need a judiciary for that. So why do we have a judiciary? We have a judiciary simply to audit whether the state's actions are compliant with the Constitution or not, and whether they violate constitutional rights or not. It is this audit function and then if the unlike a mere auditor, a guardian function. Once that audit shows that the Constitution is violated and constitutional rights are not being protected, then they have to enforce those rights, right? That is their limited role. And the idea of rule of law and protection from arbitrary personal rule by individuals is a central part of the constitutional scheme, without which everything will collapse. And a central part of that is to make sure your determination is based on objective facts, not on false narratives or exaggerated narratives, but on actual facts. And now I think we should perhaps turn to the question, which is, what is the standard of facts necessary, as part of your question on the role of judges, to put someone in jail? What is the standard? I can't hear you.
Before we do that, Dr. Gopal, I'd like to bring the question of selective prosecution, a point that you again made in your article. Now, this is again an argument that I have not seen often been made by either academic scholars or by lawyers. And you write that this is a threshold issue and should have been a threshold issue in the case of Father Stan Swamy, because you believe that he was singled out for prosecution by the government to stop him from supporting poor tribals, and a point that he himself made before the court. So you say in your article that this is the defense of selective prosecution, that the prosecution is vitiated because it is based on arbitrary or prohibited grounds and should have been dealt by the judiciary as a threshold issue, because that could have meant just quashing the entire case. Now, there are many such cases, including the case of Delhi riots, where student activists have been quote unquote framed. There are other cases where lawyers, scholars, academicians, they have been quote unquote framed in cases of sedition, other national security laws. And they have been time and again pressing that they have been singled out because of their views. So you believe that the judiciary now should take these cases and decide the issue of selective and false prosecution as a threshold issue? And does the Constitution permit that?
Yes. I think that those are very, very important issues. They're slightly distinct issues. The issue of the jurisprudence of selective prosecution is quite well developed in other jurisdictions, because it is a very big problem. And the selective prosecution is actually a crime. To prosecute someone on selective grounds for which the executive and the police should be held accountable. What is selective prosecution? It is when there is prosecutorial discretion, and that is legitimate, but when prosecutorial discretion is exercised on grounds that are prohibited by the Constitution or by the law, such as race, such as political beliefs and ideology, or political opposition, then the entire prosecution fails and must be set aside. This is the judicial standard. The famous case on this is an 1886 case in the US Supreme Court called Yik Wo, Y-I-C-K-W-O, the Chinese name, Yik Wo, pertains to the targeting of some Chinese individuals for violating laws against the operation of certain businesses in New York. So the prosecution was assailed on the ground that we've been singled out because we are Chinese. And in this very famous case, the US Supreme Court said that even if the law appears to be impartial and fair on its face if the law is applied and administered by public authority with an evil eye and an unequal hand, so as practically to make unjust and illegal discrimination between persons in similar circumstances material to their rights. The denial of equal justice is within the prohibition of the Constitution. So this is a violation of Article 14. You cannot apply the law with an evil eye and an unequal hand, selecting people because of their political views, their activities, they're coming in the way of corporates taking over land. These are not things that I said. I said these are claims made by Stan Swamy in court. I'm not saying that's true or not, but I'm saying Stan Swamy made these claims that I am being treated, I am being singled out, and those claims should have been enforced. Now, should have been evaluated. Now, are these claims new to Indian jurisprudence? No, because I can tell you without revealing the name, without his permission, because I don't have his permission. When I wrote an article on selective prosecution in a national newspaper, I got a personal letter from one of India's topmost, most respected, most experienced lawyers, right? And he wrote in that saying, look, I'm so happy to see the reference to Yik Wo after a long gap, because he said this case, Yik Wo, was often cited by, and then he named another very senior lawyer who's no longer around, and said this. So this was frequently cited and referred to in the early days of our republic in the Supreme Court, which means that the Supreme Court and the judiciary was very alive to the risk of selective prosecution, that is, people being singled out for illegal and unconstitutional grounds for prosecution, but somehow that's fallen by the wayside. And prosecutorial discretion is simply not being examined or questioned as a threshold issue. There are the issue, very rarely the issue of false evidence or false prosecution is taken up after the trial is over, and an acquittal of these charges are a prerequisite for that matter to be taken up. Whether someone was framed or falsely charged is only taken up now after acquittal is over. By then, many years have passed, all the damage has been done, and given that there are many cases where convictions are reversed on appeal, it is also quite illusory, because you're deprived of your right to protect yourself against false prosecution and framing simply because a court has wrongly acquitted you, and it'll take another many years before you know that it was a wrong acquittal. So therefore, what the standard, the legal standard, rule of law standard requires, the Constitution requires, is that any reasonable complaint of selective prosecution, discriminatory prosecution must be examined as a threshold issue. Equally, the charge of framing must be examined as a threshold issue, because if the answer is yes, a person is being selectively prosecuted, yes, a person is being framed with false charges, then that prosecution has to fail. That you cannot go on with it's a criminal waste of public resources to go on with a trial which is vitiated by selective prosecution or framing. It is a fraud on the public of this country. So it must be taken up as a threshold issue and determined before the main trial is taken up, after being cleared of the doubt, the suspicion on whether the prosecution is acting illegally or not, because that is again what the Constitution requires. So this is an issue that has simply not been given the attention that it deserves, and we are being robbed of our rights. So that why even the police, the situation is such that today someone goes and makes a complaint to the police, and the police writes it up as an FIR, making the most ridiculous charges, like we saw when Justice Chandrachud released this person, that he posted something in the social media, and then a complaint was launched, FIR was launched under national security law, and for 2 odd months he was put in jail. So now it seems like a police complaint, a bare police complaint by any random person is enough to put you in jail and have charges against you and a trial against you, and take away, before you know it, 15, 20, 25 years of your life, when all of society thinks that you are some kind of criminal because you've got criminal charges against you. And then politicians make speeches saying, look, he is on bail. Even if he's on bail, basically implying that he's a criminal. So this situation is completely, the rule of law has completely failed. We are put into the power of random people, the ability to initiate a prosecution against you by simply making a baseless, unsupported charge, which is then converted into an FIR, a case is lodged, and then there is no stopping this train until some court somewhere, if and when some court has the sense of responsibility to acquit you of these charges. So yes, we must put the focus back on the responsibility of the judiciary to protect us against selective prosecution and against framing as threshold issues. And we must demand that, and we must say that a failure to do this is a violation of the Constitution and the violation of the rule of law.
Connected with these twin issues of selective prosecution, false prosecution, and
No, let's
narrative detainees.
keep this selective prosecution and framing. Let's say they're all part of false prosecution is linked to those things. But what we are really talking about is framing and selective prosecution as two distinct ideas. Yeah.
Right. So connected with these twin issues is the recent disclosure that some of the Bhima Koregaon accused were on illegal surveillance, and their phones were perhaps compromised through a Pegasus spyware software, which was only licensed to government entities, including Government of India.
Yes.
Do you think that further strengthens this argument that many of these accused were politically targeted and were already on the watch list of the government?
You
Through,
know,
and they were being pushed through illegal surveillance?
yes, without doubt, it does. And the fact is that governments all over the world, without probably any exception, engage in selective prosecution and engage in framing. And the question is, how do we protect ourselves against it, and who is responsible within the state to protect us against that? Or is that going to be reduced to a subsidiary issue? Or will the allegation that I am being framed get the priority that it got when Justice Ranjan Gogoi, as the sitting Chief Justice of India, said, I am being framed? He called the Chief Justice's court into session on a Saturday morning and basically said, I am being framed. And what did the judiciary do? They immediately asked one of the most respected former justices of the Supreme Court, Justice A.K. Patnaik, to inquire into this. And was Justice Gogoi prosecuted for the complaints made against him for his for his alleged conduct towards his staff member? No, never happened. So a complaint was made, it never resulted in FIR, it never resulted in prosecution, and no one said, okay, if Justice Gogoi gets acquitted, then we will see whether his complaint of being framed is good or not, right? But this was taken very seriously by the judiciary. But this should be taken, selective prosecution, the charge that people are being singled out, and that we are seeing in this country, people who are speaking out for the poor, people who are speaking out for the defenseless, they are being singled out for prosecution. Let me also point out that selective prosecution does not rely on the fact that the prosecution charge is false or wrong. For example, there is a man who, this is an actual case in the United States, a racist policeman is catching motorists for speeding. And it turns out that every single motorist he catches is African American. Now, there is evidence that they were speeding. It's not that they were not speeding. They violated the law. But that entire prosecution in its entirety is struck down because they say the state cannot act with racial prejudice. So even if you committed a wrong, a legal wrong, that you cannot be prosecuted on the basis of prohibited grounds such as racism or political enmity or political rivalry, because then what will happen is that the state will wait for you to make a mistake, target you, wait for you to make a mistake, and then produce the evidence and put you away. And what is in danger then is really democracy and the rule of law, because those who are violating the law are not being targeted and watched for violation of the law in an independent manner. Only those who the state doesn't like, the executive doesn't like, only they are being watched. Meanwhile, the other guys are committing crimes because they're not being watched, because they're on the right political side or the right ideological side. They're not being watched. So what will happen is that rule of law and safety and security of the country is going to go down if the state is only focusing, misusing the law enforcement to achieve its illegal and prohibited aims, which is what is going on. All the time that has been spent in finding out tiny errors but may or may not have been done by political opponents. If that time had been spent actually tracking down, terrorists, real terrorists, or real criminals, and protecting people, then the law and order in this country would improve. And that is the purpose. That is why judiciary should protect selective prosecution.
For
Protect
example,
us, sorry, I have to correct myself. Should protect us against selective prosecution or from selective prosecution.
for example, there is no way to know, and perhaps one day, I believe that some government comes and does an audit that this spyware bought by the government of India, to what extent was it used for political surveillance, and to what extent was it used for tackling crime and terrorism?
Yes.
Uh,
Because crimes are mounting. See, the crimes are mounting everywhere in the world, and there is, but as Justice Stevens said, within the framework of rule of law, which demands the fair and equal, not criminal invigilation and prosecution with an evil eye, as the U.S. Supreme Court very evocatively said, but with an even hand, right, to protect all of us. I think that's what the judiciary is, a corrective, an audit. It has an auditive function. It should make sure that the state functions in accordance with the Constitution.
and it should not be diversion of the energy, the resources, the manpower, and the overall state apparatus towards malicious, false political prosecutions.
Intended only to keep particular individuals or particular parties in power.
Exactly.
And meanwhile, what is the price we are paying? The price is we can't sleep peacefully at night, because there is no one watching out to make sure that the criminals are being, the genuine criminals, or criminal gangs and mafias, including those who traffic women, those who most of these those who commit incredibly depraved crimes against Dalits and the minorities and the marginalized people of this country. Those are the people that should be watched, so that the citizens of this country will be safe.
So there is a paradox where a state is getting mightier and mightier in terms of arming itself with stronger laws, a very wide network of surveillance, all the technology and machinery at its disposal to keep an eye on individual movements. On the other hand, the crime and acts of terror, they continue to surge. So thank you so much, Dr. Gopal. It was, yeah,
Ashish,
you wanted to add something. Yes.
one thing I do want to say,
Yes.
and just very quickly, just to put it on the list, I think the big challenge here is, how does the judiciary deal with errors being made by judges of law, uh, which are not corrected or correctable on the judicial side through appeal and review processes? Because all systems in the world must have corrective mechanisms to guard themselves against judicial error. And judges are human beings. They don't make more errors than any other set of human beings, but they also don't make less errors than any other set of human beings. And the question is, we have to ask, what are these mechanisms that are in place to ensure that the system guards against errors being made on the judicial side? And those are, we have the Judges Inquiry Act, that's like a huge sledgehammer. and it's very rarely used because it's also guided by, again, political considerations, not with an even hand. And there is the internal procedures of the judiciary, which are very opaque and therefore have very little, command very little public confidence. So I think this instance of Stan Swamy offers the judiciary, especially the Bombay High Court, an opportunity to offer the people at its own initiative, as it decides appropriately, a way to examine independently whether or not errors were made, and if so, how they should be corrected, not as a review of judicial action by the judiciary, because that's a separate issue, but simply as an institutional review of its own functioning, and respecting fully judicial discretion and the independence of judicial decision making, and not substituting for judicial review, but some institutional review is necessary. And I think, I hope that the Father Stan Swamy's death will not go in vain, and will result in some institutional innovation in protecting people against judicial error in future.
One hopes so, Dr. Gopal. Ironically, just a day before yesterday, Bombay High Court made a remark, the same bench which was dealing with Stan Swamy's bail applications, that they have immense respect for Stan Swamy's work, the work that he did for the tribals and for the poor and the disadvantaged. How ironical.
How ironical. I wish to be in a position where I can say for future Stan Swamis, that I also say, like the judges have, that I have enormous respect for the work of the judges on Stan Swamy or future Stan Swamis. They should make sure that their work also commands from the heart equal respect from the citizens.
Thank you so much, Professor Gopal, for your very interesting and very innovative views on the issue of rule of law, judicial independence, and constitutional guarantees. That was Professor Mohan Gopal speaking to the leaflet. He crafted some very innovative arguments about selective prosecution being a threshold issue. He made some also very innovative arguments on judicial independence, and also narrative independence, which is so critical these days, when we are dealing with the specter of authoritarian government and overuse and overreach of police powers. I hope that you enjoyed watching Dr. Mohan Gopal's and listening to his views. And one hopes that this debate continues and there is more spotlight on the functioning of the judiciary and how judicial independence can be secured through institutional means, through self-correction means by the judiciary itself. Thank you.